Appellant Ms Adesotu and London Borough of Lewisham.
Yes, Ms Davis.
My Lords, I appear in this appeal with Mr Bano sitting behind me. Mr Underwood and Mr Calzavaro appear for the respondent, and you should also have written submissions from the Equalities and
We have two versions of them.
I'm slightly cross that the HRC put in a document which was not in permission. It doesn't make much difference in substance, but if they're going to do that, they should ask for permission properly.
Was that the appendix, my
No,
Lord?
the one at tab 11 is dated the 14th of June and refers to my order of the 20th. That's not the way to behave.
No.
It doesn't make much matter in substance, but it just somebody must make a note that if they're going to do that, they should re-ask for permission.
Yes, I think what
It's
emerged...
not your fault, it's not your client.
No.
But, if anybody's in court,
There is solicitor for the EHRC here. I'm sure she will have heard, my Lord. Yes. Thank you.
Anyway, Ms Davis, you can take it that we have read all the skeleton arguments and we have read the judge's judgment and obviously the notice of appeal.
I'm grateful for that. My Lord, just on housekeeping, the respondent has very helpfully numbered the paragraphs of the review decision. I think that's just been handed in.
Oh, has it?
Yes.
Right. It would be good practice for review officers to do this as a matter of course, which I think I have suggested before. But,
it's in one of your judgments, my Lord, and it would be good practice for us as counsel to do it in advance as well. Helpfully, the respondent remembered yesterday afternoon.
Well, that's very helpful.
It can go in at C 169 to 181 if that
Sorry,
helps.
we're going to put it where? In the core bundle?
In the core bundles.
Yep. At page...
169 to 181.
Yeah.
It's the same page numbers,
Right.
simply that the paragraphs have been numbered.
Right.
My Lords, as you know, this is an appeal against the order of His Honour Judge Luba. Your Lordships have read the judgment. That in itself was judgment on a section, on a application for strikeout within a section 204 appeal brought under the Housing Act 1996. And that appeal was in respect to the review decision that I've just referred your Lordships to. And that review decision decided that Lewisham had discharged its main housing duty under section 193 of the Housing Act as a result of my client's refusal of accommodation at 220 Algernon Road.
As I understand it, whether your client did or didn't refuse is still the subject of an appeal.
Indeed.
Which is not before us.
Indeed.
And that's what Judge Luba or some other circuit judge is going to decide when it all goes back.
There were in the end 6 grounds of appeal within the 204, and 2 of them plus 1/3, as it were struck out by His Honour Judge Luba. The others remain live pending your Lordship's decision. My Lord, can I deal very briefly with the factual background? Yes. And I should have checked, do your Lordships have a small supplementary bundle?
Yes.
Thank you. Because that's the factual background is in there.
Right.
There was an offer of accommodation. The offer of accommodation was made to my client by letter that was dated the 22nd of May, but was actually hand-delivered 3 days later on the 25th of May 2018, and that was the Friday before the May bank holiday. And the reference for that is page 13. Yeah. My client was unhappy having received that offer, and there are internal notes from Lewisham at pages 17 and 18 of the supplementary bundle, where she leaves a message saying, it's the top of page 18,
yeah.
Your Lordships will see that it says B. Frederick 30th of May in bold type, but immediately under that it's from Harrington Zoe, sent the 25th of May 2018, 12:05 to Brian Frederick. She said that she was offered PSL, that's private sector lesson, today. She's been given a copy of the offer letter. She's not signed. She's saying that she needs more time. She tried to kill herself last year, etc., etc. Please, would you have a word? So she's unhappy. And on the previous page, bottom of page 17, Mr. Frederick speaks to her at 14:45, where she is saying that she has refused to accept, where Mr. Frederick's note records that she says that she refused to accept it.
This is the 25th of...
This is the 25th of May, so
This
that's
is
the
the
Friday.
Friday.
The previous note we looked at was the 30th of May.
I'm sorry, no it wasn't, it's very confusing.
Oh, I see, I'm
I
sorry.
can only assume that 30th of May is some sort of cross-reference or date when
25th
printed
at the
out.
top.
If your lordship looks at 25th.
It's the light type rather than the bold
It
type.
is, yes, yes.
Okay, I'm sorry about that.
Took me some time to get my head around that as well, my lord. So the top of page 18 is the message. The bottom of page 17 is the telephone call, and she has various reasons for wanting, for being unhappy with the offer, which will be eventually a subject of.
Yeah, and she's given till Tuesday to make up her mind. isn't
And
it?
she's given until Tuesday to make up her mind. She then sends an email on the following day, the Saturday, which is towards the bottom of page 18. And again, we're in the light type. If your lordships,
The whole punch.
by the whole punch, your lordships will see towards the end of the fifth line down, sent 26th of May 2018, 1732, to Frederick Bryan. Subject is the offer of housing at 220 Algernon Road. Following the content of your email, I can confirm to you that I have accepted the offer of the property. On the other hand, under section 202 of the Housing Act, it's my right to request a statutory suitability review of the property. I would like to exercise that right. And she then goes on and gives reasons. Obviously, Lewisham then received that on the 29th of May, which is the Tuesday after the bank holiday. And Mr. Frederick responds just above that. It's all the same entry, I'm sorry. On the 29th of May at 14:54, your lordships have it. Thank you, I will treat this as a refusal. So one of the grounds which doesn't
Sorry, I
concern...
haven't got that. Which was that?
I'm sorry, we're still on page 18.
Yes,
It's the last substantive entry.
yes.
We were looking at about a third of the way down at the email sent 26th of May, and then we go up to the top of that entry. And we see
I see. Got it, thank you.
from Frederick Bryan sent 29th of May, and he's responding.
Got you, thank you very
Yes.
much.
And he says, I will treat this as a refusal. You are, of course, entitled to review. Within the 204 appeal, not something for today, is a point about whether or not Lewisham were right to characterise that as a refusal.
Yeah.
She also sent a letter in which she sent by post on the 27th of May, and that is at page 12 of the supplementary bundle. Where she doesn't use the word, either the word accept or refusal. It's headed request for a statutory suitability review. The above property has been allocated to me for accommodation. I'm requesting a review, and she gives her reasons. That letter is not received until the 4th of June.
Yes.
What also happens on the 30th of May is that Mr. Frederick speaks to the appellant twice on the telephone, and that's at page 19. He speaks, and it's the first substantive entry, again in bold, B. Frederick, 30th of May 2018, 11:25:56. He telephones her, and she says that she can't answer now because she's breastfeeding, and they agree that he will call back in 2 hours' time, which he does. Just below that, at 13:25, phone call to applicant about accepting the offer. She answered the phone, and after talking all around this issue for a while, I told her that she's either going to move in or not, and I require an answer. She refused to confirm that she would move in. I told her that I concluded that a position is that of refusal. She did not confirm that she'd moved in. She would move in, so I advised her that I would be discharging the duty. She'll receive the notification shortly. And the letter in which Mr. Frederick notifies her that the duty is discharged is referred to at page 19, further down, where he sends an email at 16:30. The discharge notification has been posted to you. If you would like a copy to be emailed, please confirm, kind regards. And that decision letter we don't need to look at, but for your Lordship's notes, is in the core bundle at page 179. The receipt of the letter of the 27th of June, of May, the Sunday of the bank holiday, received on the 4th of June, is then treated as a request for review. Mr. Matthews activates the review process, and in fact the only information that is then submitted on review besides that letter dated the 27th of May is a letter from my client's perinatal nurse, which in fact is not in the bundle, but it's summarised to some extent in the review decision, in which she says that my client suffers from complex PTSD and depression with psychotic symptoms.
Yep.
And that was the material before the review decision. We have the review decision at page 169, and included in the review decision is a decision that my client is not a disabled person,
Yes.
according to the definition in the Equality Act.
Would there have been a minded to find letter before the review decision?
There was
maybe
not.
Should have been.
There's only a requirement in those circumstances where the reviews officer takes the view that there was a deficiency
That's true,
or
yes.
irregularity in the original decision. And I'm so sorry, there was a minded to letter. It's not in your bundle, but it was dated the 6th of June. And what arrived possibly in response to it, or in any event, is the letter from the perinatal nurse.
So the process is that your client has an opportunity to make representations to the review officer.
Yes.
She has another opportunity to make further representations when she gets the minded to find letter,
Yes.
and then the review officer makes the decision.
Yes. Having received the information that we've looked at, plus the letter from the nurse. My client at that point had not sought any legal advice or any other formal assistance.
And just help me on this, was it alleged that she was disabled at any point during the review process?
Not during the review process. She didn't put it as such. She did say that she
said she was depressed.
She said she was depressed. The reviews officer, of course, knew about, from the message in the notes, the trying to kill myself a year earlier, and there was the information from the nurse. Subject to my junior checking the terms of the letter from the nurse, I don't think anybody said in terms she is a disabled person. Certainly she did not say so. The question, of course, for Lewisham is whether on the information before them there was a real possibility that she might be, and they had to consider that, and they did. My Lords, as I say, the grounds of... Let me just follow on with that point about the disabled person. It is our case on the appeal on the point of law that she is a disabled person on the basis of her depression and her complex PTSD. And it is also, of course, our case that the judge should determine that for themselves in the Section 204 appeal. But for the purposes of today, of course, we're dealing with jurisdiction. And we are not dealing either with Lewisham's finding or whether that was wrong on a point of law. So the purposes for today is the extent to which discrimination grounds of disability discrimination or indirect discrimination, or indeed, it doesn't concern this case, but potentially direct discrimination can be raised, and those on the point about jurisdiction can be raised in relation to any protected characteristic, whether it's disability or any of the others, sex, race and so on.
Yeah. But if you're right, and the judge decides that your client was disabled at the relevant time,
Yes.
but there is no legal flaw in the review officer's decision that she wasn't, it's just a disagreement on the facts, you would have two concurrent and contradictory findings of fact.
Well, no, because we would say that the judge's decision was obviously applying the law as set out in the Equality Act, on the basis of the factual scenario and evidence before the judge. Clearly, Lewisham's decision was that she is not a disabled person, and we say that as a matter of law, the judge can consider whether that is correct applying Section 6 of the Equality Act. Therefore, if the judge decided that that conclusion was wrong, it must be a decision on a point of law, not a point of fact.
And that's within the ambit, you say, of Section 204?
Yes. What could be said against me, my lords, is that, in fact, Lewisham's decision that she's not a disabled person is put very briefly indeed. But if one had a decision that set out a number of factual findings, following which the local authority decided that somebody was not a disabled person, then clearly the judge could only overturn those factual findings on the basis that they contained errors of law.
I'm not sure.
I haven't put it very well.
I'm not quite sure I understand that. You said a moment ago that if the judge decides on the facts that the applicant is disabled, then the reviewing officer must be wrong in law.
If the judge decides on the evidence before the reviewing officer that as a matter of law that evidence leads to the conclusion that somebody is disabled, then that is a finding that the reviewing officer applied the law wrong.
Sorry, let me just write that down because I want to make sure I understand this. Have I got this right? If the judge decides that the evidence before the reviewing officer leads to the conclusion that the applicant is disabled, the judge can set aside the reviewing officer's decision on that point.
Yes.
Right. So
Applying the
that is there is a legal error in the review decision, because on the facts found by the reviewing officer, the only sensible conclusion is that the applicant was disabled.
The only legal conclusion is that the applicant is
Right, I
disabled
understand
indeed.
that.
Yes.
So that does not require the judge to make any findings of fact. That requires the judge to examine what the review officer decided and then apply the law
Yes.
to those facts.
Yes. Yes.
And I can see that you might be in a position to say that the inquiries made by the review officer were inadequate.
The attack, hypothetically, would be that, or quite simply that the review officer had misunderstood the extent of the depression,
Right.
the evidence that was before a reviews officer as to the extent to which the depression had a substantial and adverse effect, long-term.
As I understood the appeal before us, you are arguing that the judge on a Section 204 appeal is able to make his own primary findings of fact. Have I got that right?
We are arguing that the judge is able to make a finding of fact as to whether or not, a finding as to whether or not the local authorities' conduct of the review constituted disability discrimination or indirect discrimination.
Conduct of the review.
And the review decision.
I'll say, you're not saying, I thought the consequence of the first point you elucidated to my lord was that the RO's decision would be set aside and the case would have to be sent back for a new review decision. That's not your case then. You're saying that the county court judge decides, well, there is a disability and therefore query whether there's been any relevant discrimination under the Authority Act.
And makes a finding as to, a legal finding as to whether there has been discrimination.
How could the judge do that? Wouldn't it's a much wider review, isn't it, than the simple point you've just been very helpfully elucidating as to really primary facts, these evaluation disabled under the Act. Therefore, the next stage is a further finding of fact, isn't it, by the judge?
Well,
Am I wrong there?
the judge has to look at various points, and the respondent has very helpfully set out in their skeleton argument a list of what they say a judge would have to consider if we're right. And that is at, give me a moment, Your Honour.
That's their addendum, is it?
It is their addendum, and,
27.
sorry,
Page 82.
82, I'm grateful. And the respondent puts it in terms of 8 matters to be found in respect of a claim of disability discrimination under section 15, 6 to be found in respect of indirect discrimination, and potentially another 4 to determine a claim of discrimination by a service provider under section 29. And it's right, of course, that both section 15 and section 19 don't stand by themselves. The question is whether there is discrimination in the delivery of a public service under section 29. We say, in response to that list, that the first point is that quite often a protected characteristic will be obvious, because the issue about discrimination doesn't just apply to disabled people, so it could be sex and race and so forth. So
Well, everybody has a number of protected.
everybody has a number of protected characteristics. So it may well be that there is no issue about the protected characteristic. It is just clear. So in terms of the first point at 122.1 or 123.1, the protected characteristic might be obvious. There are circumstances, particularly with disability, where it may not be, but bearing in mind that this is not just about disability, the idea that a judge will necessarily have to carry out fact-finding if we're right is not correct. Moving on to what a judge would have to do where it is not obvious, and most likely in the case of disability. Again, the disability itself might be obvious. Somebody may be in a wheelchair, somebody may be blind, somebody may have one of the matters that are deemed to be a disability, such as cancer or HIV and so forth. And so the question raised by the respondent and also by my lord about determination by the judge as to whether somebody has a disability is not going to arise in all these cases, and indeed is likely to arise in very few of them. Where a judge would have to do that, because I'm not ducking the question, then we say that the judge does that, determines whether somebody has a physical or mental impairment on the basis of the evidence,
What evidence?
The evidence that was before the reviewing officer.
So, right.
The judge takes that evidence and applies the legal test in the Equality Act.
Is this then, are you making the distinction between, that occurs often in ordinary civil cases, about the findings of primary fact and the legal evaluation of the results of those primary facts?
Yes.
An evaluative decision,
Yes,
multifactorial, whatever you like to
That's exactly my point, yes.
So you're not suggesting, just to make this clear, you're not suggesting that your client would be entitled to give evidence or call evidence, expert evidence perhaps, before the county court judge to enable the county court judge to make his or her own findings? You're restricting yourself at the moment to the evidence that was before the reviewing officer.
I'm saying that there is the evidence before the reviewing officer. That potentially could be amplified in a witness statement, particularly on my lord's suggestion that one of the errors of law might be a failure to make inquiries. And so the client could possibly say, well, the reviewing officer has found that my symptoms of depression don't prevent me from engaging in the activities of daily living, but actually the reviewing officer never asked me, and if they had asked me, this is what I would have said. I have difficulty getting out of the door during the day and so on and so forth. So there would clearly be an issue about inquiries, and in that respect, the client could amplify it.
How can that be a question of law? I don't understand how, whether the claimant has a physical or mental impairment with a long-term effect on her ability to carry out normal day-to-day activities is a question of law.
Because that's the legal definition.
No,
And
of course that's the legal definition. But whether this particular claimant, on the evidence available to the reviewing officer, had a physical or mental impairment with a long-term effect on her ability to carry out normal day-to-day activities is surely a question of fact, not a question of law.
Not if the reviewing officer had misapplied the statute, misapplied the test. That then becomes an error of law.
But sorry, I don't understand what you mean by misapplied the test. That's the test
Yes.
to be applied. But whether Ms Adesotu satisfied it is surely a question of fact.
The factual basis that then lead to application of the test are questions of fact. And in the background are whether or not the reviews officer has made all necessary inquiries into the issue and acted fairly and so forth in that respect.
That may be crucial. What evidence do you say a reviewing officer ought to commission? Experts report? Employment consultants report?
Well, it depends on the case. It depends on the evidence before the reviewing officer. But much more simply, ask the applicant. And so, if the reviewing officer is minded to take the view that somebody may have a mental impairment, but that it does not have a substantial and long-term effect on their activities of daily living, then unless there is already material before the reviewing officer that says this is the effect on me, then the reviewing officer should just simply ask the applicant, and that we would say would be a necessary inquiry.
But the reviewing officer presumably would have said in his minded to find letter that he's minded to find that the applicant is not disabled.
The reviewing officer in his minded letter, minded to letter, was in the same terms as the review that we have in front of us, and simply said,
You're not satisfied that you're disabled.
yes, I'm currently minded that you do not meet the definition of disability under that
so
Act.
if that was going to be challenged, there was an opportunity to challenge it.
Yes, and the letter came in from the nurse.
Yeah. So in order to advance the case on disability, she puts in a letter from the nurse,
Yes.
which says she's depressed, but doesn't say she's disabled.
Says she's depressed with complex PTSD and psychotic symptoms. So, more than depressed.
Right.
It's somewhat summarised in the review decision, but we say not fully.
I mean, I can see the argument for saying that given that material before the review officer, the review officer ought to have concluded that your client was disabled.
On application of the legal test, yes.
And in reaching the contrary conclusion, the review officer has misdirected himself in law.
Yes.
But I can't at the moment see why that requires the judge to make findings of fact, rather than saying the review officer got the test wrong, it goes back to the review officer to make a fresh decision.
Well,
Or rather back to the housing authority to make a fresh decision.
that would be one ground of appeal. So happens that it's not in this case, but it would be one ground of appeal. But we're saying, in respect of grounds 1 and 2 that were struck out, that the issue about disability or any other protected characteristics is only one part of the issue that a judge needs to be considering. Because we're saying that the judge needs to be considering whether there was disability or indirect discrimination as a whole. So part of that is, do you have a protected characteristic? If there's an issue about that, then the judge has to look at the evidence before the reviewing officer and determine whether the reviewing officer got that part of the decision wrong. And then the judge has to go on and apply the other parts of section 15 and section 19.
But you're saying there should be a full discrimination inquiry by the judge on 200 people?
On the basis of what is in front of the judge.
Front of the reviewing officer, I thought you
On
said.
the basis of what is in front of the reviewing officer, and if there are inadequate inquiries, if there's an argument about a lack of correct procedure, then that could be amplified.
Yeah.
So you say that in every case of application for housing, a decision maker and then the reviewing officer are bound to make all inquiries that the material if the material before them gives any ground for suggesting that the applicant may be disabled.
And that's established law, my lord. That's the case of
No, just
Peretti
let
and
me finish the
Enfield.
sentence.
I'm so sorry.
The reviewing officer is bound to obtain evidence as to whether the claimant satisfies the various tests under the Equality Act for showing you are disabled. If that means getting medical evidence, if there's a short nurse's letter which doesn't really cover the point, must get a full report and so on before making a decision.
My lord, what the authority of Peretti and Enfield says, which is at tab 12 in your authority bundle, is that where on the evidence before the reviews officer there is a real possibility from that evidence that a person is disabled and that disability, and we would say or other protected characteristic, is relevant to the issue that the reviews officer has to consider, then the reviews officer does have to, give me 1 moment, I'm just looking for my notes on Coretti.
Paragraph 33, isn't it?
It is. It's 32 and 33. The point is that there should be further inquiry where some feature of the evidence raises a real possibility that the applicant is disabled, and that's relevant to the question that the reviews officer has to consider. So that's...
You're going on, aren't you, to say that exercise should be carried out by the judge too?
Well, where I'm going on, because that applies to consideration of Section 149 public sector equality duty. And subject to our ground 2 and the issue about antecedent policies and so forth, then there's no question that that is a statutory duty where, if it's relevant, the reviews officer has to consider. And if they are wrong in law in considering it, that can form the basis of a 204 appeal.
Well, I mean, I can see that.
There's no
I can see
question
that
about
it can be a valid ground of appeal under Section 204 to say that the review officer has failed to comply with the PSED.
Yes.
I understand that.
Yes.
But that doesn't entail the judge making findings of fact.
No, it entails the judge looking at the process of inquiry that the reviews officer went into, where there was some feature of the evidence raised a real possibility that the applicant was disabled. So that's established in relation to the public sector equality duty. Where we go further is to say that that should apply because a judge could be considering claims of disability discrimination or indirect discrimination. That's where we go further.
Yeah.
We then say that the same point applies to the number of other matters, which again the respondent has set out for us in the appendix to their skeleton argument. And so, page 83. And so in relation to disability discrimination, 122.4, that the judge would have to consider on the evidence whether or not the claimant had been treated unfavourably.
Well, I'm sorry to interrupt you yet again, but I'm looking at the amended grounds of appeal to the County Court, page
Yes.
168A, because these are the grounds which the judge struck out.
Yes.
And what you say in ground 1 is that Lewisham breached section 19, and in ground 2 that Lewisham breached section 15.
Yes.
You don't say in either of those grounds that the review officer did anything wrong, that he failed to make inquiries or he didn't do what he should have done. Your allegations in these grounds are directed against the council.
Well, the reviews officer acting on behalf of the council. The review decision in itself, we say, is the discrimination. I'm not entirely sure I follow your lordship's distinction.
Well, yeah.
I'm not sure I understand what they're saying discrimination was.
Well, what we
Or
say,
maybe it is.
what we say, and again, it's if your lordships are with me on jurisdiction, it's a matter for the Section 204 judge.
Okay.
But
Okay,
we
I suppose leave that alone.
All right.
You're not asking us to say that there's judge was wrong because he didn't make a finding
No, no,
in this respect. It's got to go back to the judge.
no.
To tell you that.
I'm asking your lordships to say that the judge was wrong to strike out on the matter of
All
jurisdiction.
right, fair enough.
So, my lords, having determined the issue of protected characteristic on the evidence before the reviews officer, and as I say, in most cases that will be, of protected characteristics, it will be obvious, and indeed probably agreed. It's most difficult with some forms of disability. Then the next stages are whether there is unfavourable treatment, and in the case of disability discrimination, whether there is unfavourable treatment because of the claimant's disability. And again, I say that that is something that the judge can find as a matter of law from the documents that were available to the reviews officer. And in this case, to answer my Lord McCombe's question, the reviews officer should have been considering whether the timescale for acceptance was long enough on the basis of what we say is her disability.
Without the slightest suggestion that it wasn't.
She had not raised that, that's right. Well, if there is evidence that leads to a real possibility that she might be disabled, the reviews officer then needs to apply that to all the relevant questions. And one of those questions could be, did you have long enough? And when one looks at the communications from my client, on the basis that they were equivocal about acceptance and refusal and so forth, then we say it was an obvious point for the reviews officer to have considered, and we go further and say that applying the Equality Act, it is a point that the judge should be considering for themselves on the basis of the information that was before the reviews officer.
Can you say all these are questions of law?
Yes, because they are applications of the Equality Act.
So whether somebody has been treated unfavourably in consequence of their protected characteristic, you say is a question of law.
Yes.
Speaking as a retired discrimination practitioner, I don't see how it can be. These are questions of fact which, in the employment context, tribunals decide every day of every week, which in the non-employment case, county court judges have to decide. But they're surely questions of fact. Whether somebody has been treated unfavourably in consequence of their protected characteristic is surely a question of fact, not a question of law.
First of all, we say it's for the reviews officer to look at that.
Yeah.
Whether or not it's raised on review, it's for the reviews officer to look at that if a relevant protected characteristic emerges. Secondly, we say that it is a matter of law whether, if we move on to indirect discrimination, for example, whether there is a provision, criteria or practice, a PCP, and that is something that is clearly ascertainable from the material before the reviews officer and then before the judge.
So it's inherent, is it, that in your submission that the reviewing officer must ask himself whether the council's policy is a lawful policy.
Yes. both in respect of discrimination and when I move on to ground 2.
And he must
well-
ask himself that question, whether or not it's been raised.
It's inherent in discrimination. In respect of ground 2, I say something slightly different, so I'll leave that for ground 2, but it is inherent in discrimination. Whether or not it has been raised, providing that on the evidence, the Peretti test, there's a real possibility that a protected characteristic is there, and of course that it's relevant, because as your lordship says, we all have them. So the reviews officer must look at that. And the 204 judge must also look at that. And decide whether in this case Lewisham's practice of offering 24 to 48 hours was a provision, criteria or practice. And whether that provision, criteria or practice put people with relevant protected characteristics at a particular disadvantage compared with not, those who do not.
Well,
And a similar exercise applies in terms of section 15.
there are two steps, aren't there? I can see the point that you say, well, the reviewing officer must decide for himself whether or not the housing authority's policy is lawful, where there's a real risk of discrimination,
Yes.
and that he must do that whether or not the question is raised. And that's a Peretti, if you like,
Yes.
in this thing, expansion Peretti, but nonetheless within the spirit of Peretti.
It is both of those things, yes.
I understand that argument, and I can understand that you may be able to say, on an appeal under section 204, well, the reviewing officer didn't do that, so he was in breach of the PSED, and therefore the case has got to go back for him to carry out that exercise. But it's quite a different proposition to say the judge must decide whether the policy is a PCP which puts the disabled at a disadvantage. That's a completely different question.
It's an additional question. Yes, my lord.
And that's the question before us, is it?
Yes. Yes.
Because if you say the flaw in the review decision is that the review officer didn't consider any of this, then that's not the issue that we're deciding.
That's relevant to PSCD. What we say under our ground 1 is that the flaw in His Honour's judgment in striking out our grounds 1 and 2 was that section 204 encompasses a consideration by the judge of discrimination under section 15 and section 19.
As opposed to a consideration by the judge whether the reviewing officer properly considered it.
Yes.
Yeah.
Yes, we do. We say that the judge has to make findings for themselves about whether, legal findings about whether there was discrimination.
Right. I understand the argument.
Yes. And two last points on that. One is we've gone through the various matters that a judge would have to decide on the basis of the evidence before the reviews officer. But the final point in relation to both section 15 and section 19 would be whether or not the treatment or the PCP was a proportionate means of achieving a legitimate aim. That's a much obviously broader evaluative question. Again, we say it would be a question for the judge because it's an issue of law. And we entirely acknowledge that the local authority in particular would put in evidence supporting the proposition that it was a proportionate means of achieving a legitimate aim. And
Yes.
indeed, in this case, the local authority did just that. And the witness statement of Mr Matthews, the reviews officer, sets out Lewisham's case for having a short period in which to consider an offer and so forth, and that is the obvious demand on temporary accommodation. So that evidence can be before the judge, and the judge can weigh it as a matter of law. I also, and then they're not in your lordship's bundle, but in our skeleton we do go through some of the principally administrative court decisions where clearly discrimination can be raised within judicial review.
Yes.
There's no prohibition. It's exempted in the Equality Act from section 1131, and those authorities are summarised at page 10 of our skeleton, which is pages 37 to 38 of the bundle. So this exercise is something that administrative court judges have grappled with no difficulty. And when one reviews the cases, then in nearly all of them there are protected characteristics that are either obvious or are conceded. Some of them are the basis of sex or age or so forth. Where there is an issue of disability, that's been conceded. That was in the case of XC in Southwark. And the judge commented that Southwark were correct to make that concession. It's only in one of the cases, G in Hillingdon, where the first instance judge found that refugees as non-EU nationals were not, did not have the protected characteristic of race, and that was overturned by the Court of Appeal. So the issue about whether or not somebody has a protected characteristic has been something that administrative court judges, of course exercising the same jurisdiction as that of section 204, have grappled with. They have found in all of those cases that a PCP has been potentially indirectly discriminatory, either on the basis of evidence from the court or because it's obvious on the face of the, frequently they're looking at allocations policies, and therefore it is the document and the judge can analyse it. And then much of the issue comes down to whether or not those schemes, those PCPs, are proportionate means of achieving legitimate aims. So this is something that administrative court judges, with the jurisdiction of an error of law, have been applying with no difficulty.
These looking at the list, I'm afraid I haven't studied them all again, some of them I'm familiar with, but cases of where there's a sort of policy or allocation scheme under challenge in relation to classes of people, rather than looking at a sort of individual claim like your client,
Yes.
who claims to have certain difficulties,
Yes.
where there's a much more acute finding of fact on the question, for example, whether Algernon Road is closer to a school or not, or whatever it may be.
Yes.
Those are much more acute findings of fact than, for example, the ones that you've summarised here. Is there any difference between them?
Once one gets onto the policies, then yes. I mean, whether or not the particular applicants have protected characteristics, as I say in XC, she put forward evidence that she was disabled, and Southwark conceded that point, and the judge said that the concession was correct. In G and Hillingdon, there was arguments about whether or not Mr G had a protected characteristic. When one then gets on to, as my lord says, the issue about whether her protected characteristic then puts her, whether there's a PCP that puts her at a particular disadvantage because it tends to be indirect discrimination rather than disability discrimination, then yes, one looks straight at the allocation scheme, and the judges are dealing with much broader concepts than as my lord says, whether or not that particular offer was suitable. But our discrimination points are not brought about the offer, they're brought about Lewisham's practice, in particular the period of time that she had for acceptance of the offer, and whether or not Lewisham's characteristic of her response as a refusal amounted to a PCP or to disability discrimination. So in that, the grounds 1 and 2 don't deal with her reasons.
Well, it's even
they deal
narrower
with
than
process.
that, isn't it?
Sorry?
It's even narrower than that. It's a particular kind of disability. It's the only one that's relevant. I mean, if you're in a wheelchair, you don't necessarily need more time to make your mind up.
No.
Or if
No.
you're blind, you don't necessarily need more time to make your mind up.
Yes. Yes.
So
Yes.
it's a particular kind of mental impairment, which you say means that your client requires more time to
Yes.
reach a decision.
Yes. That's the nexus. That's the link. Yes. If it was a different set of facts, then whether or not there was discrimination about different matters would be a different issue. We say on this set of facts, then the issue is that her disability as a protected characteristic, and whether that disability meant that the Lewisham's timescale amounted to either disability discrimination or indirect discrimination. We don't say that that applies across the board. But in terms of the jurisdiction point, we again step back and we say that whether or not somebody could raise this as Section 15 or Section 19 within 204 grounds is correct within as part of the 204 jurisdiction, and that there might be other circumstances of a PCP. For example, if a local authority required somebody who had considerable mobility difficulties to come into the office to sign, that there might be other examples of PCPs that become relevant.
Yeah.
My Lords, if I can just very briefly mention the additional points that we make in our skeleton in respect of ground 1. The starting point, of course, is Section 113 of the Equality Act, where subsection C says that proceedings must be brought in accordance with that part, but then at subsection 3, a claim for judicial review is exempted from that. And we have said in our skeleton that given the very clear authority from the Court of Appeal in Nipper Begum and the House of Lords in Runa Begum, that the Section 204 jurisdiction is the full range of issues on judicial review, that one has to read that exemption for judicial review as including Section 204s. And we make the point that in both of those cases, it was not said that the full range of issues on judicial review, except for discrimination issues, should be raised in Section 204. There was no exemption put into that. We also refer in our skeleton to the fact that there is no doubt that Equality Act issues can be, and allegations of Section 15 and Section 19 discrimination can be raised by way of defences to possession proceedings. And two examples of that are Lewisham and Malcolm and Astor Communities and Ackerman and Livingston. Yep. Defences are not specifically referred to in Section 113, and therefore we say Section 113 can't be entirely exclusive. And we deal with the authorities of Hamnet and Summers, which were both claims for statutory reviews under specific acts.
Yes.
And in both of those cases, the Court of Appeal in Hamnet upholding Mr Justice Singh as he was at first instance, and the Administrative Court in Somers hold that discrimination cannot be brought within those statutory reviews.
Can you just point me to the paragraph of the skeleton, if it's there, Mr.
31, I think, on page 38 of the bundle. And I think, if I remember rightly, Mr Justice Singh, in the Hamlet case, said judicial review in section 113 equals a claim brought under CPR Part 54.
He does.
He said it's a legal term of art.
He does.
That's what it means.
Yes. It's tab 22, page 1161.
Tab 22.
Yes.
Yeah, paragraph 15.
Yes. He says precisely the words my Lord said. It's a phrase claim for judicial review. Section 113 is a term of art referred only to a claim for judicial review in the strict sense under CPR 54. And of course we are not under CPR 54.
No.
And what I would say quite simply is that that authority, both at first instance and the Court of Appeal and Somers in the Administrative Court, was not considering a position where the Court of Appeal and the House of Lords had said that the particular jurisdiction, in our case 204, had the full range of judicial review.
You say it's wrong.
I say that it applies in respect of statutory reviews, but that argument was not heard about whether or not it would apply to a jurisdiction that has been determined to have the full range of issues on judicial review.
Yeah. In section 204, statutory wording
Yes.
says that you can appeal to the county court on any point of law.
Yes.
That's the statutory jurisdiction.
Yes.
Section 204A, which we haven't got, I think, in our bundle, which is about interim accommodation,
Yes.
also gives you a right of appeal.
Yes.
But it goes on to say expressly that the court must apply the principles applicable to judicial review.
Yes.
So it doesn't say it is a judicial review.
No.
Could have done, but it doesn't.
Yes.
Likewise, 204 could have said it's a judicial review, but it doesn't.
No, but the 204A was inserted in the as a result of the Homeless Act 2002.
Yeah.
And therefore following Nipa Begum and following Runa Begum, probably following Runa Begum, I would have to check my dates. Runa Begum is 2003, but certainly following Nipa Begum.
Yes.
So the principle was established for section 204 by way of case law. Parliament then confirms that or reaffirms that when they insert 204A.
204A. And you might have thought that when the Equalities Act came to be drafted, Parliament knew that this was the approach taken under section 204 and expressly required to be taken under 204A.
Yes, and that leads to two conclusions. Either Parliament, by choosing not to mention 204's made a conscious decision to exclude discrimination, or we say that Parliament was well aware that the jurisdiction of 204 was that of judicial review and therefore felt that it didn't need to say so, to put it slightly colloquially.
Right.
My Lord, there is also much emphasis in both of our skeletons on the on fact finding in section 204 and on the authority of Borough and Wandsworth.
Yes.
And my Lords have my submissions as to the extent to which the discrimination claim would not involve fact finding.
Yeah.
Clearly there have to be decisions made on application of the law to the facts before the evidence before the reviews officer. the Equalities and Human Rights Commission bring
Let me
the...
just pause a moment. To take a case like this, where the question of discrimination was never raised in front of the reviewing officer,
Yes.
and let's suppose that you are able to, in theory at any rate, to bring a claim based on indirect discrimination. You accept that the local authority can attempt to justify its PCP,
Yes.
and that must surely involve the judge in making findings of fact about what it is, the reasons for it, whether they're a legitimate aim, and whether the reasons for the PCP are a proportionate means of achieving that aim. All of which are questions of fact, aren't they?
Well, they would be made on the basis of the evidence before the
Well, of
judge.
course, but judges always make findings of fact on the basis of the evidence.
The approach towards proportionality is, we would say, principally a matter of law,
Really?
whether or not something is proportionate.
Again, I'm just intervening there, Ms Davis. Again, thinking back to discrimination law. Obviously, a lot of cases have gone on appeal, but this court and the Supreme Court tend to say that if an employment tribunal, in an employment case, has found that X is a proportionate means of achieving a legitimate aim, it's very difficult to upset that on appeal, because it's a finding of fact by the employment tribunal.
The issue would be, to a certain extent, the evidence before the judge, one assumes, about the demands on temporary accommodation and so forth in this case. One can, as it were, take it as read that was in Lewisham's mind when they made their decision. And there are certainly authorities within the housing context, well, this Pinnock, which is in your bundle, which says that proportionality and legitimate aim, there are a number of matters that a housing authority seeking possession would not normally have to put forward.
Criminal records matters, for example, in AR against Manchester Police, Lord Carnell has looked at the extent to which proportionality it can be dealt with on questions of challenge in relation to proportionality of a criminal records scheme. And there's another area which I'm afraid I don't recollect the exact words, but it was how does an appeal court deal with issues of proportionality as being considered a 2018 decision? I might have to refresh my memory.
There's also the child case of Reed B.
Yeah, Reed B, exactly.
Also deals
Lord
with
Newberger's 7 stages of
appeals.
wrongness.
Yeah.
Yes. Yes.
Always neglected in the white book.
So, a judge would have to have those legal principles in front of him or her. But I do come back to the submission that I'm making, which is that just as a judge would have to identify whether there was a provision, criteria or practice, we say as a matter of law that so the assessment of proportionality and legitimate aim would at that stage be for the judge, on the basis that the local authority had already impliedly gone through that assessment. But the judge would then have to review that, applying the law on proportionality.
Right. And you say that fits within BUB?
I do, and one of the points in BUB, it's tab 14, my lords.
So you, just before we go to BUB, you accept that BUB binds us, is that right?
Yes.
Right. Because the EHRC seem to be saying forget BUB, the law's moved on, but you don't say that.
I don't go as far as the EHRC, no. I say that BUB clearly binds your lordships, on the issue of should a 204 judge be determining questions of precedent fact in the case above, whether or not a letter was received.
Right, so we're going to Bob. Yep, tab 14.
Going to Borough, and the approach is set, first of all, we start at page 1017, paragraph 15, and it's Lord Newburgh when he was Master of the Rolls.
Yes.
And he distinguishes the House of Lords decision in A in Croydon, where of course House of Lords did hold that the question of whether or not somebody was a child was a matter of precedent fact. And he distinguishes that on the basis that that was the that decision was reached on the wording of the Children Act. He makes the point that Lord Justice McCombe was making at paragraph 19 about the complexity of value judgments to be made by local authorities. And at paragraph 20, he sets out 5 essential points. The assessor of an authority's duty under section 193 depends inter alia on the applicant having been sent appropriate notice. Where the applicant disputes the authority's contention that the duty has ceased, she must refer the issue for review. Whereas here the applicant says the duty has not ceased because she was not sent the appropriate notice, the review must consider and determine that issue. Any appeal to the Court of Law against the review's decision is limited to a point of law. Accordingly, there is no jurisdiction under statutory scheme for the County Court to set itself up as a finder of the relevant primary facts for itself.
You would emphasise primary facts.
Yes. Yes.
Not an evaluative decision on the basis of primary facts. Is that the distinction you're making?
That is, and applying the legal test in the Equality Act. We're saying that we're asking a judge in a 204 to do something very different in considering discrimination to hearing evidence on the basis of whether or not a letter was received.
Whether or not?
A letter was received,
Yeah.
which is the case in Borough.
Yeah.
That you say is a real primary fact case, presumably.
Yes, yes. We derive some support from that from the following paragraph 21, where Lord Newburgh says this analysis appears to me to be entirely consistent with the notion that the exercise carried out by the County Court under section 204 is in substance the same as that of the High Court in judicial review, Lord Bingham in Bruna Begum, and we come back to the point that discrimination claims can be litigated in judicial review.
Yes.
We also point, when one looks further down at the subsidiary contention about whether the judge should have heard oral evidence, and at paragraph 24, Lord Newburgh is looking at the extent to which a judge could do so in the administrative court. I accept that it is, as a matter of principle, open to a judge hearing a judicial review application to permit one or more parties to reduce oral evidence, Lord Diplock and O'Reilly and Matman. However, for reasons of both principle and practice, such a course should only be taken in the most exceptional case. As its name suggests, judicial review involves the judge reviewing a decision, not making it. If the judge receives evidence so as to make fresh findings of fact for himself, he's likely to make his own decision rather than to review the original decision. Also, if judges regularly allow witnesses and cross-examination in judicial review cases, the court time and legal costs involved in such cases will spiral. In the overwhelming majority of judicial review cases, even where the issue is whether a finding of fact should be quashed on one or more of the grounds identified by Lord Bingham, there should be no question of live witnesses. Even the provision of further documentary evidence which was not before the original decision, must often be questionable. However, particularly given the nature of hearings under section 204, the wide terms of section 204.3 and the good sense and experience of the County Court judges, nothing in these observations is intended to cut down the flexible and practical approach to section 204 appeals adopted by the County Court, let alone the practices of the Administrative Court. So we say that whilst hearing oral evidence, and indeed to a certain extent additional written evidence, is deprecated, it's not entirely ruled out. What judges should not be doing is making decisions on these, as my lord called it, hard facts, precedent facts. But that judges can make decisions on discrimination matters. Not least because, as the House of Lords said in Lewisham and Malcolm, the matter of discrimination, if something is unlawful because of discrimination, then the court cannot uphold an unlawful decision. And we say that when it comes to considering discrimination in judicial review, not only have judges been perfectly comfortable with doing so, but the right approach is in the ADAF Israel Authority, which is at tab 25. And page 279.
What was this case say? What's this ratio?
This was a judicial review of the North London coroner's policy, which was not to prioritise how she treated dealing with deaths.
She applied what essentially was a cab rank rule, didn't she?
She applied a cab rank rule, and that was challenged by an Orthodox Jewish lady on the basis that was, a number of reasons, but it included discrimination, on the basis that failed to take account of the Jewish requirement for early burial. And the same, of course, applied to those of the Muslim faith.
Yeah. So it's paragraph 136.
I'm grateful. That's right. So the divisional court finds that in the circumstance of the case, we've reached the conclusion that this court not only has jurisdiction to consider the complaint, that's section 1133A, but should do so on a number of reasons. Firstly, permission had already been granted. It had not excluded arguments based on discrimination. Secondly, this is not a typical discrimination case of the sort which would be better suited to determination in the county court. For example, where there are disputed issues of fact and live evidence will need to be heard in cross-examination. And we would say that that applies to County Court Part 7 proceedings, where there is a straightforward claim of discrimination in the provision of services, but that section 204, as judicial review, is not about disputed issues of fact and live evidence. But just as with judicial review, it can be...
Well, that goes back to the question whether a claim for judicial review in section 113 does or doesn't include section 204 appeal.
Yes.
And there was no question, there's no doubt about the jurisdiction of the divisional court in the Appellant Israel.
No, this is about whether it should be.
Whether, as a matter of discretion, they should
Yes, yes.
hear the claim.
So we're saying that these principles would also apply to the issue of discrimination within section 204.
Right.
And your lordships have the rest of that paragraph. And we also make the point that if discrimination cannot be raised within section 204, there is no bar on it being raised in Part 7 private law proceedings.
Yes.
And therefore, in terms of an effective remedy, and in terms of, as it were, proportionality of proceedings, then it is far more effective for all the matters to be heard together by one judge on one occasion, both discrimination and other matters that arise within 204, rather than having two sets of proceedings, potentially with different timescales, leading to the possibility that a section 204 judge might be making a decision on whether the review decision contained errors of law without considering discrimination, and subsequently a county court finds that the process that the local authority has engaged in did constitute indirect discrimination. That would cause difficulty.
Yes.
Since there is no bar on somebody in the position of my client bringing a Part 7 claim for discrimination in respect of the provision, criteria or practice applied to her, then it is effective to hear the two together. And in terms of effective remedies, we say that for a homeless applicant, what she wants is a quashing order. She wants a judge to say that the review decision was unlawful, including as a result of discrimination, and for that decision to be quashed and her situation to be considered again.
Yeah.
She's not, damages are much less of an effective remedy for her after the event if she's lost her right to be housed by the local authority.
It's a matter of coherent narrative, Ms Davis. Where is she being accommodated now?
She remains in the accommodation that she was living in when she refused the offer at Algernon Road.
Yes.
And Lewisham have agreed to continue that accommodation, certainly pending this appeal, and I think, although I may be corrected, pending the determination of
substantive
204.
Section 204 appeal.
Yes.
Yes, I see a nod from Mr. Allen.
My Lords, if I may, I'll go on to ground 2. Can I just
Yes.
confirm that there's no other matters to raise on ground 1? Ground 2 is the judge's decision that the County Court doesn't have jurisdiction under Section 204 to determine the lawfulness of any antecedent decisions, policies or practice. And that's based directly on the wording of Section 204, subsection 1, that the jurisdiction is any point of law arising from the decision, and that's the last page of tab 2.
Yes. It occurred to me that there may be something in the decision of this court in Abed and Westminster that bears on this question. Abed, A-B-E-D, and Westminster. I've got copies, if you would like to have a look. We wouldn't deal with it now, obviously, but at some point. I think I might have given somebody a highlighted one, never mind. It's the decision of this court, and the key paragraph is paragraph 26. But you will need to read it all.
Yes, can I come back to your Lordships on that? So, my Lord, the point about antecedent decisions, policies or practices,
Yeah.
it is clearly right that when a 204 judge is considering the review decision, they do not go back and look at the original decision. And my learned friends point to William and Wandsworth on that. You don't have appeals against both decisions. Save for the one procedural matter where a reviews officer had failed to spot that there might be a deficiency or irregularity in the original decision, and had therefore failed to activate the specific procedure under regulations, now 7.2. So normally a previous decision would not be looked at except in that issue. But there is the issue of looking at previous policies, and those might be policies such as we say there was in this case, around how long she had to accept the offer. But they might also be much more policies that are undoubted and undisputed. For example, policies governing the allocation of temporary accommodation, which your lordships considered in the case of Alibiket and Brent.
Is there in fact a policy in this case? Have we seen it?
There isn't a written policy. Our case, if your lordships are with me and you restore ground 2, is that the period of time that she was given was a policy, and that therefore can be considered.
Is that common ground or is that in dispute? I mean, Mr. Matthews, I think he says that your client was given extra time.
Yes.
We don't know whether that's a policy or one-off decision or.
But ground 2 and His Honour Judge Luba's judgment goes much further than that.
We are to assume there is a policy. Is that right?
For the case of for this process of dealing with the jurisdiction, your lordships are to assume that there is a policy.
And what is the policy we are to assume?
The policy which Mr. Matthews does refer to, he says it's not a policy, but he says that normally clients are given 24 to 48 hours to confirm whether they have accepted the offer of accommodation or not.
Right, that's normally. So
Normally.
Presumably are exceptional cases, otherwise he wouldn't use the word normally.
Just an administrative efficiency, isn't it?
And then
you're
you get-
elevating that into some sort of national social policy.
Well,
Cloud cookie land with respect.
the difficulty, my lord, is that the consequence of His Honour Judge Luba's judgment on ground 2 go much further than saying, well, there wasn't a policy.
Yeah.
He is saying that the jurisdiction at section 2041 prevents an applicant in a 204 appeal from raising any issues about what would be an undisputed policy. And so ground 2 goes much further than the issues about whether or not there was a policy in this case. He doesn't strike us out on the basis that it's obvious there wasn't a policy. He strikes us out on the basis that even if there was a policy, section 204 prevents a challenge of that. So that's very wide-ranging.
But I understand that, but I'm speaking for myself, I'm not sure that we ought to be ready to decide this ground on a hypothesis that perhaps the judge was wrong to say that even an undisputed policy can't be challenged. But in this case, like my lords, I can't put my finger on what is the policy which you say is open to challenge. The evidence seems to be, normally we expect a decision within 24 to 48 hours. In this case, we allowed more. So what's the PCP which is indirectly discriminatory?
Well, your lordship has it. We say that normally does amount to a policy. Whether or not there was an exception in my client's case is a different point, and we would say that in fact the longer period was because of the bank holiday.
The normally plainly means that the 2 days is not applied in every case, it's normally applied. Therefore it is part of the policy that in abnormal cases the 2 day limit is not applied.
Well,
That's part of the policy.
He doesn't particularly go on to that. What he says is there is no specific council policy regarding the timescale. With most offers of alternative temporary accommodation, clients are given 24 to 48 hours.
Yes, that's what he says in para 25, and in para 31 he says that your client was given extra opportunity, more time, repeated opportunities, several phone calls, So that's the practice that was applied, which is not the normal practice. But almost any policy has built-in exceptions to cater for the abnormal.
Yes.
And your client was treated by Lewisham as an abnormal case, therefore the normal was not applied. She was given more time.
Well,
So you would have to say that that policy, that is to say, normally it's 2 days, but in abnormal cases it can be more, is it self-discriminatory?
we would, and that would have been ground 2 before the judge had he not struck us out.
But sorry, how can the PCP be discriminatory? That we expect a decision in, say, 48 hours, but in appropriate cases we give more time. We did in this case. What's wrong with that?
Can I just say that we dispute that more time was given. We say more time occurred because it was a bank holiday. But the issue in ground 2 is, I'm sorry, my lord, but it's not what's wrong with that, because that's an issue before the judge if there's jurisdiction. And I understand the point about not deciding on a hypothetical basis. But the problem that we have in ground 2 is that the judge's decision, and he makes it very clear, is not just about that a policy was not discernible or was appropriately applied in her case, or that it wasn't a policy and so forth. He is very specifically striking out ground 2 on the basis that policies that a local authority adopt cannot be subject to an appeal on a point of law under section 204. And that it relates to the number of authorities that my Lord Justice Lewison has heard about contracting out decisions. It also relates to policies about the allocation of temporary accommodation, and theoretically there could be other policies, but those are the ones that tend to be live issues.
Can you remind me which paragraph of the judge's judgment specifically says that?
Well, what he does,
I know what you mean, but I just can't remember it.
he puts it twice.
It's really paras 97 or 95 to 98, isn't it?
Yes, that's right.
It's 112 of the bundle.
Thank you very much.
That's
And
right.
what he seems to be suggesting, it's obviously my fault for setting this hair running, but what he seems to be suggesting in 97 is that the reviewing officer is entitled to treat the policy applied to the applicant before his own decision as lawful.
Yes.
And then he says in 98, it wasn't suggested before the decision that there was any public law irregularity or other unlawfulness.
Yes.
And he's already made the point, or he's recorded Mr. Underwood's submission at 95, that the reviewing officer wasn't asked to consider its lawfulness. So the judge, as I understand it, is really not saying much more than if you want to challenge a policy, time to do it is on review.
Yes.
And if the reviewing officer refuses the challenge wrongly, then you can appeal against
Yes.
it. But if you didn't ask him to consider the lawfulness of the policy, you can't now, on a section 204 appeal, claim that the policy is unlawful.
Yes.
I think that's what he's saying.
I agree, and I say that's wrong.
Yeah.
Yes.
I don't think he's saying, as your ground 2 suggests, that the county court never has jurisdiction to consider the lawfulness of a policy. I think the judge is accepting that if the lawfulness of the policy were challenged on review,
Yes.
then you could take that further under section 204.
Yes. Yes.
But you say that the requirement of challenge is wrong. You can do it anyway.
Yes.
Yeah.
Yes. And that's the issue, whether you can do it anyway.
As I
if it's
understand,
not
that's the
been
difference
raised.
between the two sides. I don't think Mr. Underwood is saying that there are no circumstances under which a section 204 appeal cannot encompass a challenge to the policy. I think what he's saying is you've got to ask the reviewing officer to decide it first.
Yes, no, that's clearly Lewisham's position, and it was also clearly His Honour Judge Luba's position, because he provides the useful litmus test of paragraph 99,
Yeah.
where he says that the issue is
Yes.
whether or not it can be properly rewritten.
Yeah. If the point's
Yes.
not taken before the RO, then you don't take
Yes.
it. Yeah.
Yes, and we say that's wrong, that the scope of section 2041 can include a challenge to a policy whether or not the point is taken before the reviewing officer.
Yeah.
And we also say it's important precisely because of principally policies around the allocation of temporary accommodation in the context of homelessness. And we rely on 2 points, 2 authorities. The first is Baroness Hale in the Supreme Court in Ms Adesotu, which is tab 19.
Yeah, but she didn't address this point.
No, well, what she says is it's page 955.
Which tab is this?
19.
Yes.
And it's paragraph 40. And it's the last sentence, having explained in paragraphs 39 and 40 and given guidance that local authorities ideally should have policies for the allocation of temporary accommodation. She says in the last sentence, it would enable applicants to challenge not only the lawfulness of the individual decision, but also the lawfulness of the policies themselves. There is no cutting that down. Obviously the point was not raised to her, but there is no cutting that down to if the challenge is brought during the review process. So
Well,
she
she
says,
doesn't, no, as I said, she just doesn't deal with the point.
well, she doesn't deal with that the particular issue of whether you
No.
have to challenge it first, to challenge it in the review process first. But she does envisage, in general terms, a challenge to a policy within section 204. And she doesn't cut it down. And then she makes it clear that she's talking about section 204 by the first sentence of paragraph 41. Indeed, it would also enable a general challenge to these policies to be brought by way of judicial review. In some ways, this might be preferable to a challenge by way of an individual appeal to the county court. So she's making it clear that she is talking about section 204. And then there is my Lord's decision in Ali Bickett and Brent at tab 26 in December last year, where
Yes, I think I said if you've got a policy and the policy is lawful, then generally speaking your decision will be lawful.
you did.
But
My
again,
Lord,
the point wasn't an issue.
but what your Lordship also does at paragraphs 90 to 92
Yeah.
is you consider Brent's policy as regards the length of the letter. And you find towards the end of paragraph 91, there's nothing in Brent's policy which restricts it to 2 years, 2-year tenancy. You quote the policy and you say that is entirely in line with the statutory criteria. So your Lordship there is considering the legality of Brent's policy. In circumstances where Mr. Ali Bickett had not raised in review that the policy was wrong. He'd raised certain issues about his own case and so forth. So your Lordship entertained a challenge to the policy, or rather your Lordship allowed a 204 judge to entertain it, and then your lordship reviewed that,
Yeah.
and there was no issue, but your lordship could make a decision on the legality of the policy. Now, I take the point that it was not argued in front of your lordship that Mr. Alibicket was prohibited from raising this point because he hadn't raised it in review, so your lordship didn't consider that. But there would be many practical difficulties if the scope of section 204 was restricted to that. Not least because, as in my client's case, many people who seek review decisions are not represented. And therefore simply put in the bare bones of what is at issue, why I don't like the property and so forth. An argument that the policy that a local authority applies in, say, the allocation of temporary accommodation is a complicated argument, not one that an individual is likely to consider for themselves. They just want the reviewing officer to agree with them that the reasons why they've turned the offer of accommodation down are wrong. And therefore to exclude a later consideration by a judge about whether or not a policy is lawful on the basis that it wasn't raised would, we say, be dangerous, in that it would potentially prevent acknowledgement that a policy, where a policy was unlawful, that it was. Your lordship has said directly in your lordship's comments in Adesotu that you are concerned about applicants taking technical points which don't affect individuals, and your lordship said that in the context of a challenge in, not actually in Adesotu, in the associated case of Smith and Haringey, where there are challenges to the local authorities' decisions around contracting out. And my lords, we don't dispute that where there are technical points which do not affect the individual, that those should not necessarily be brought. But what we are concerned about...
But how do you stop that?
Well,
there's no leave requirement under section 204.
there is no leave requirement on section... One comes back to the common sense and flexible approach of county court judges who would deal with what one might call arid technical points very quickly, and would make the point, relying on your lordship's comments, that these are technical points which do not affect the individual.
So they what? Go to discretion on the remedy? Is that how you put it?
Well, first of all, they might find very quickly that there is no error of law.
Well, suppose there is an error of law. Suppose that I can't remember which authority it was, didn't have the power to contract out. Nothing wrong with a review decision. The reviewer applied the law absolutely correctly, got everything right, but there was a flaw in the procurement process, and the service should not have been contracted
It
out.
could certainly go to discretion, yes, as to remedy, because there is that discretion, and a decision can be upheld.
So your solution to that conundrum is the county court judge would say, well, yes, I agree that Mr X wasn't the right person to make the decision, but as there's nothing wrong with the decision itself, I refuse to quash it.
And that would not be wholly surprising from a county court judge. But what we do say is that the difficulty with the technical points which do not affect the individual, in the case of the contracting out points, is that one then comes to points that do affect the individual, such as the allocation of temporary accommodation, whether in Mr Alibicket's case it should be in Smethwick, those are important points for the individual, and the individual should not, those policies should be lawful. A reviewing officer is entitled to presume that they're lawful if the point isn't raised on review, but that should not exclude the possibility of a 204 applicant raising the legality of that policy insofar as it affects that applicant. The alternative is that the 204 applicant would have to do so by way of judicial review, which again leads us to a plethora of proceedings, rather than having a 204 county court judge determining the lawfulness of the policies and errors of law that arise in the review decision. And the applicant may well run into time limit problems in terms of bringing a judicial review, because the policy might have been adopted some considerable time earlier, at a time when that individual, if they were aware of that policy, might have no reason whatsoever to believe that the policy would be relevant to them. They might be housed at that point and subsequently become homeless. It might never occur to them that Brent's policy on the allocation of temporary accommodation would be relevant to them, and they ought to consider the lawfulness of it. So we say that when one looks at the contracting out cases, that the decision of Mr Justice J in Tacky and Well in Hatfield, where he heard, sitting in the High Court, but it had been transferred to him as a Section 204, that Section 204 was designed to operate in exactly the same way as the judicial review, and that he had jurisdiction to consider the contracting out point in Tacky, was correct.
Yeah.
It should have bound His Honour Judge Luba. Of course it doesn't bind your Lordships. We note your Lordship, my Lord Lewison's comments in Adesotu or Smith, but we say that there is a real danger that if policies cannot be challenged in Section 204s, if they've not been raised on review, that an applicant would be deprived of raising an important issue of lawfulness that does apply to them. Your Honour has it. Would your Lordships, I'm sorry I called you Your Honour, would your Lordships give me one moment just to confirm there's nothing else? My Lords, I haven't addressed the case of Abed. Perhaps I could come back to that in reply.
Yes, of course.
Yes. And my Lords, there are grounds 3, 4, 5 and 6 put in by the respondent. Essentially they say that we've failed to raise these matters in the Section 204 grounds. We've dealt with that. This is an appeal against the decision to strike out. We say this is all about jurisdiction. Is there any other matter I can help your Lordships on? I'm grateful.
Thank you very much, Ms Davis. Yes, Mr. Underwood.
My Lords, before I begin, perhaps I can hand up Section 7 of the Human Rights Act 98, which for some reason has not made it into the core authorities bundle. I have 3 copies, and your Lordships will have seen that I refer to this in our response to the Commission's submissions.
So where should we put that?
Rather than add a new tab, my Lord, I would suggest we put it behind the Housing Act 96.
Behind the Housing Act, right.
In tab 2.
Behind, back of tab 2.
Yes, ma'am.
Thank you.
Yes.
Well, my Lords, as my learned friend has rightly pointed out, taken together, the appellant's notice and the respondent's notice raise 6 grounds, consecutively numbered. I propose to address your lordships orally on grounds 1, 2, 3 and 5, and as in my submission grounds 4 and 6 probably require little oral development.
Well, where are these written down? So,
These are written down in the respondent's
your skeleton, are there?
skeleton argument, starting on page 58 of
Yes.
the core bundle.
Yeah.
Lord, working backwards, ground 6 appears page 86, paragraphs 111 onwards.
Page, sorry, just give it
86.
86. No, hang on. That's
Yeah.
I've got an 86.
No.
Right.
80. I'm so sorry, it's page 80.
Sorry?
Page 80.
80.
That's ground 6, is it?
Indeed, and ground 4 appears on page 79.
Ground 5's on page 79.
Ground 4 should be just above it, my lord.
On page 78.
Yeah, 79.
That's it, yeah.
I think. So you're going to address us on
On grounds 1, 2, 3 and 5. 1 and 2, of
1
course.
and 2 are on page 57, is that right?
That's correct.
Right. Next one.
That's the beginning of your skeleton argument.
Actually, no, my lord. The submissions in the appeal commence on page 71 of the skeleton.
Oh, I see.
That deals with ground 1, my lord.
That's ground 1, right?
Right, okay.
Ground 2, of course, is very brief because we recognise that His Honour Judge Luba QC was bound by the decision in Tashi, but we say for the reasons given in ground 3, his decision should be upheld nonetheless. So grounds 2 and 3 can be taken together. And my lords, it will be my submission that ground 5 naturally follows on and is a logical adjunct to ground 3,
Yeah.
relying upon the authority of Cramp and the proposition already raised by my lord that the issues now raised by the appellant were not in fact raised before the review officer. So, my lord, for this purpose it would be helpful if you flag up both of the respondent's skeleton arguments, the first of which we've already seen at page 57, and the second appears at page 90J.
That's your response to the EHLC.
That's the response to the Commission. And indeed the Commission submission itself, which appears at page 90B. So to summarise, I'll deal with ground 1 separately, grounds 2, 3 and 5 together, and leave your lordships with 4 and 6 on the written submissions. Before I start to develop ground 1, my lord, a brief word, if I may, about the nature of the grounds that were raised before the County Court by the appellant. There was some discussion in my learned friend's submissions about the nature of the grounds that were advanced, in particular under grounds 1 and 2. It would be instructive, my lords, if we turn to those briefly. They appear at page 168A to 168B of the core bundle.
Are they the same as set out in the judge's judgment at 101?
I believe they are, my lord, yes. The brief point I wish to raise is this. It is, and always has been, the appellant's case, as is quite clear from grounds 1 and 2, that what the appellant was asking the County Court judge to do was to decide these issues for himself. There was never any challenge, per se, to the lawfulness of the review officer's treatment of a particular issue, not least, of course, because he was never asked to deal with it. So grounds 1 and 2 are no more, no less than a bare claim under Section 29 of the Equality Act 2010, alleging a contravention of Part 3 of the Equality Act on grounds of disability and indirect discrimination. Again, it is and always has been the appellant's case, both before this court and below, that those alleged contraventions should be determined by the judge himself in the context of the 204 appeal. And it is that, we say, that the county court simply cannot do. So, my lords, beginning with ground 1.
But you would accept then, would you, that you could bring a section 204 appeal saying the reviewing officer failed to make sufficient inquiries?
Yes.
Or the review officer made some other error in not dealing with the applicant fairly, or whatever it was.
My lord, yes. My learned friend suggested a hypothetical ground that in the decision that the defendant, the appellant, was not disabled, the local authority failed to make adequate inquiries about the nature of her impairment. That would be a perfectly proper ground of appeal under Section 204. I don't object to that.
Yeah.
It would be equally open to the appellant in an appropriate case to say that the local authority's finding that she was disabled was a finding that no reasonable local authority in fact, could possibly reach.
Yeah.
Pause then, Lords, to note that was never a challenge brought by this appellant in this appeal. So the finding of disability was never challenged on public law grounds or otherwise, but I accept that it would have been open to her to do so. The fundamental distinction here, my lords, which your lordships already have, I know, and is probably tried, is what she cannot invite that court to do is make those findings for itself in order to determine an alleged contravention of Part 3. And under ground 1 of the appeal, my lord, we advance 2 prongs of attack. We've labelled these the Equality Act issue and the Housing Act issue.
Yeah.
And my lords may follow this line of argument from paragraph 71 of the first skeleton argument on this.
Yes.
I'll deal first with the Equality Act issue, and by this issue we maintain before this court that as the judge held in the core bundle at paragraphs 69 to 70 of his judgment and 72 to 73, sections 113 to 14 of the 2010 Act did not permit this appellant to bring proceedings relating to alleged contraventions of section 29 under part 3 by way of a section 204 appeal. The analysis, my lords, begins by reference to the statutory provisions themselves, which your lordships will find behind tab 3. Starting, if I may, with section 113. My lord, section 113 finds its place in part 9 of the 2010 Act concerning enforcement, and together with section 114 and indeed subsequent sections which are immaterial for today's purposes, they prescribe the way in which a person who alleges a contravention of various parts of the 2010 Act, including part 3, has to bring a claim before the court. So under subsection 1 of 113, proceedings relating to a contravention of this Act must be brought in accordance with this part. So far, so good. Pause there for a moment before we turn to 114. Under subsection 3, there are prescribed exemptions and exceptions to that general rule. Of course, the one on which my learned friend relies in this case, under subsection 3, is a claim for judicial review. before turning the page, my Lord, pause there to note for a moment that the other prescribed exceptions to that general rule do not list or prescribe an appeal under Section 204 of the 96 Act. And the brief point I make in the course of this submission is that had Parliament intended to include it in the 2010 Act, enacted 14 years after the 96 Act, it would surely have included it in that section.
So Davis's answer is, well, they knew from the Begum cases that it was like judicial review.
With the greatest of respects, that does not support my learned friend's submission, insofar as all that Nipper Begum and Runa Begum say, as affirmed in Cramp subsequently, as my Lord pointed out, is that the function undertaken by the County Court in a 204 appeal is akin to judicial review. It is not judicial review per se. That takes us, my Lords, to Section 114, which actually starts at the bottom of the same page, but the material parts are contained over leaf. Subsection 1 is material for today's purposes, which provides that the County Court has jurisdiction to determine a claim relating under subparagraph A to a contravention of Part 3, services or public functions. And that is the nature of the claim that was brought here under grounds 1 and 2. It was an alleged breach of Section 29, read together with, in the first instance, Section 19, indirect discrimination, and in the second, disability discrimination under Section 15. So on the face of the statutory provisions, my Lords, arguably, there was a choice of venue in which this appellant could litigate the contraventions alleged by grounds 1 and 2. Pausing there for a moment, I say arguably because we say in fact she had no choice. She had to bring a claim in the County Court under Part 7. I'll come to that in a moment. The point here is she did neither of the options under 113 or 114.
You have to say unarguably, or beyond argument.
Yeah, indeed.
This is a striker.
Indeed. I'm grateful. Nobody in this matter has argued that what the appellant did in this case was a Section 114 claim. Neither the appellant nor the Commission has taken that point. And so I don't propose to address your Lordships on the submissions that we advance in our written skeleton argument that say it cannot possibly be a claim because that connotes the court's originating jurisdiction, which a Part 52, Section 204 appeal simply is not. Question, is it therefore a judicial review under subsection 3 of Section 113? The answer to that on binding authority is plainly and manifestly no. And my Lords, to make
that
good...
passage from Mr. Justice Singh, haven't we, in Hartnett?
It's both Mr. Justice Singh, as he then was, and indeed Lord Justice Gross,
Yes.
who endorses that decision.
Yeah.
So if I may pause, my Lords, to take your Lordships to the decision in Hamlet, which appears behind tab 22 of the Court's authority bundle. I hope you'll forgive me for dwelling for a little time on this.
This is Hamlet.
This is Hamlet, my Lord, yes.
Okay.
This, my Lord, you'll recall, is the case that concerns a discrimination challenge to the rather esoteric experimental traffic regulation orders under the Road Traffic Regulation Act 1984, about which I now know a little more than I ever cared. The particular challenge brought, my Lord will see from the head note right at the very top, like this case, was a Section 29 alleged contravention. And in this case, it was read with both Section 15, disability discrimination, and indeed Section 20, which, as my Lords may know, is an alleged failure to make reasonable adjustments. The issue in that case was whether, upon the statutory review, that the claimant was able to bring as of right against the making of the ETRO. whether the High Court in a Part 8 claim had jurisdiction to consider the alleged Section 29 contravention. And materially, my lords, we start in the judgment at paragraphs 14 onwards.
Well, can we, before we go there, can we look at paragraph 8?
Yes.
And in particular, the quotation from the relevant act, which I think is the right bit, which is the jurisdiction the court was exercising. So it's Schedule 9, para 35. If you want to question the order, you can apply to the High Court.
Yes.
Para 36, court can quash the order, either generally or as far as may be necessary for the protection of interest. So it's clear that the statutory jurisdiction included a power to quash the order.
Quite. And I will say in due course, I will make 2 points before, I will get to them in due course, and they are these. The dicta first made by Mr. Justice Singh and upheld by Lord Justice Gross, that a claim for judicial review means simpliciter, a claim under Part 54, is dispositive of this issue and determinative for all purposes of the proper construction of subsection 3 in section 113. I will also say, in any event, even if you're against me on that the statutory, the reasoning, the rationale for finding in this case that the statutory review was not within the court's jurisdiction is directly applicable to a section 204 appeal for reasons to which I will come. But it is instructive, my lords, if we look at the arguments that were advanced before the Court of Appeal, but before that, the substance of Mr. Justice Singh's findings. So the argument that was put before him, bottom of paragraph 14, is that the High Court, it was contended, had jurisdiction because the concept of judicial review included a statutory application, such as the review before the court. Materially, 4 lines down in paragraph 15, Mr. Justice Singh found that the phrase claim for judicial review in section 113 was a term of art and referred only to a claim for judicial review in the strict sense under Part 54. And then, turning to the second point I highlighted earlier, that judicial review was different from an application for review under a statute, such as that in this case. That interpretation, he found, was supported by practical considerations, my lords. The admin court was not well suited to hear factual disputes of the sort that...
We can read that paragraph for ourselves.
I'm grateful. One point, if I may, before I move on, to note that towards the bottom of that paragraph, his lordship found that, in fact, the clear intention of Parliament was that claims under section 29 must be brought in the county court. My lords, turning over the page, the submissions before the Court of Appeal, before Lord Justice Gross, at the start of paragraph 18, Ms Casserly's submissions can be summarised as follows.
So sets out the submissions, yeah.
Indeed, she maintained that, in fact, subsection 3 could be construed so as to include the statutory review. The submission to the contrary is set out at the bottom of that page, and then the material parts of the judgment, paragraph 24. If I may take your lordships, paragraph 24, Roman numeral 4 at the bottom of page 1163.
Yeah.
And you'll see, my lords, there that turning over the page, Lord Justice Gross endorses Mr. Justice Singh's finding that it is the county court alone that has jurisdiction to entertain such claims. In particular, I see your lordship reaching for the highlighter,
Is this the passage you sideline, or somebody's sideline?
Indeed,
Six.
Lord, yes, it is. In brackets, he says, and only the county court has jurisdiction.
Yeah. And he says statutory review is not judicial review.
Indeed.
Which is, yeah.
That's at Roman 6.
My lords, to save us coming back to this authority later,
Do you mind if I just read this?
I'm so sorry. I'm so sorry.
Yes, thank you very much.
So the second sideline passage was the one my Lord, Lord Justice Lewison referred to under Roman numeral 6. To save us coming back later, may I invite your lordships to consider paragraphs 28 and 29.
The PSED, which is a process duty, is at large, so to speak, but the substantive matter is county court.
Indeed, and paragraphs 28 and 29, my Lord, talk about the inappropriateness of the judicial review procedure for determining bare claims of discrimination. My Lord, I will not take you to this decision because you have the point. But in the subsequent decision of Summers, a decision of Mrs. Justice May, the same point was made by her in the context of a statutory review of a public space protection order. And she makes several salient findings. First of all, it is the county court that has jurisdiction and exclusive jurisdiction to entertain claims alleging a contravention of Part 3. Paragraphs 76 and 84, judicial review is simply inappropriate to determine claims of that fact-sensitive nature. It is the county court with the ability to have live evidence, cross-examination, and importantly under section 114, assessors sitting with the county court judge to assist with relevant findings about the extent of a disability or its impact. That is the most appropriate and pertinent procedure for determining such claims. My Lords, very briefly, if I may, before moving on, I said I would deal with the attempt to distinguish Hamlet. The reasoning in Hamlet is as applicable to a Section 204 appeal as it was to the review in that case, for these following reasons. We know from Ruler Begum, Lord Millet's dicta, paragraph 98, that the county court's jurisdiction in a 204 appeal is appellate and not merely supervisory, a fundamental distinction. We know from Nipper Begum, Lord Justice Olds, pages 312G, or page 312G, that the Section 204 jurisdiction is simply akin to judicial review. As your Lordship, Lord Justice Lewison pointed out in paragraph 90 of Pagnotu, judicial review has a permission requirement, whereas a Section 204 appeal is brought as a matter of right, and it does not have that safeguard. There are important limitation differences: 21 days in respect of 204 appeal, 3 months or promptly in respect of judicial review. And of course, in respect of a Section 204 appeal, there is no pre-action protocol and no requirement for any pre-action protocol letter. But importantly, my lords, there are significant procedural differences between the two. And for this point, may I take your lordships to Cramp? To Cramp,
Yes.
which appears, my lords, behind tab 6. And in particular to the dicta of Lord Justice Brooke at paragraph 70. May I invite your lordships to read paragraphs 70 and 71 on these fundamental differences.
could I just ask a question? If there really was, let's assume for a moment, a true case that there'd been improper discrimination by an authority in
Yeah.
relation to a decision of this sort, what should the challenger do? Take the point on before the reviewing officer, is that the issue? Or does it, if you can't get to it that way, is there some sort, should you bring proceedings under the Equality Act and have them consolidated with some sort of 204s? If you've got a real case on child, I'm not saying this isn't a real case, but assume that situation has arisen, how do you get all the issues resolved by the relevant court, rather than having two sets of proceedings, or perhaps you're going to say that you do need two sets of proceedings?
I do say that. I would accept, my lord, I would accept this. In conducting a review, it is not inconceivable that either advertently or more usually inadvertently, an officer might discriminate against a person with a protected characteristic.
We're all told that one makes unconscious discrimination decisions all the time in one's life.
Indeed.
This is what I postulate.
And I recognise that in principle that could give rise to a point of law. It would be open to an appellant in principle to raise that point of law in the context of a 204 appeal, if it gave rise to a point of law arising from the review decision, a point we take up on ground 2. But what the judge in that case could not do is determine that alleged illegality for the reasons already given in respect of sections 113 to 114. It would require a separate claim to be brought.
So what do? You stay the proceedings under section 204 and invite the claimant to make a challenge under the Equality Act with the appropriate procedures. Is that what he did?
In principle, he would have a discretion under case management powers to stay the 204 appeal in order to permit a section 114 claim before the county court. Now, the point might be taken against me. Well, surely that will result in a multiplicity of proceedings and is unattractive. Well, I have two answers to that, and I make them in several points. The first is that is the state of the law. That is what section 114 requires. That is a consequence of section 114 and indeed this court's decision in Borough, to which I'll come in a moment. But several points. First of all, we can be quite confident that the number of cases in which that is likely to arise will be relatively few. Why do I say that? We know from the information that the Commission has put before this court that the number of claims brought under section 114 Lord is small. Now, in fairness to the Commission, they do say we don't necessarily know about all of them, but they are in the best position to know, and they say the number is small. The number of such issues brought in the context of a 204 appeal, logically, would be even smaller. Further, and this is a secondary point, if this issue were in fact a common issue arising in the context of section 204 appeals, then in all reality, minds much greater than mine would have brought the issue before this court long before now.
But so I thought you accepted that in the course of a review you could challenge the legality of a policy. Did you not? That's how I misunderstood.
Yes, I did.
I mean, suppose that Lewisham's policy were that we attempt to house all homeless persons with families in Birmingham.
Yes.
Well, we're not bothering to try to house them in Lewisham. Would you not be entitled to say, well, that's an unlawful policy, and say to the reviewing officer, the offer of property in Birmingham was unlawful because your policy is unlawful?
My lord, yes. In principle, if that was a policy that was proactively applied by the review officer or was required to be applied, in principle that could give rise to a point of law arising from the review decision.
Yeah.
Query, however,
And that seems to be what Lady Hale was suggesting in Nozalamino, if I pronounced that correctly. So if the policy is you go to Bletchley, you can challenge that in the review, you say.
I accept that. I accept that, but in cases where the determination of the alleged discriminatory policy involves findings of fact, and I say whether that includes primary or evaluative facts, the county court would simply not be in a position to determine that issue. And in that case, that might be, for example, my lord, a prime case in which the county court judge says, well, hang on a minute, I don't have jurisdiction to do this. Look at Bob, look at section 114. So, although
Would it depend on what kind of discrimination is alleged?
No. My lord, no.
Well, suppose that the policy was that we house applicants under the relevant part 7. We house them in Great Yarmouth unless they have been resident in the borough for 2 years before they make their application. So you've got a kind of Gulu or ward type residence requirement, which it might be said indirectly discriminates against Irish travellers or whoever.
Yeah.
Now, could you challenge that? That's a different kind of discrimination. Could you challenge that on a review?
It is challengeable, but whether in fact the county court is in a position to determine it is a different matter.
Yeah.
And that is the case in which I say sections 113 and 114 come into play, and indeed Bob. That's where, as my Lord Justice McCombe raised, that's where a county court judge might say, well, hang on a minute, I can't deal with this in this jurisdiction. In principle, I can exercise my case management powers to stay the proceedings so that you can bring your claim under section 114. And then if in fact in the context of that claim it is established that the policy is unlawful, then consequential orders may follow.
I'm not quite following why you can't do it under section 204. So let's take a hypothetical policy. We house all our applicants in Great Yarmouth unless they've been living in the borough for 2 years, I suppose, 10 years, whatever you like. So somebody says, well, I haven't been living in the borough for the requisite period, I'm an Irish traveller, you're discriminating against me. Surely the reviewing officer could consider that question and say either no we're not, or yes we are but it's justified for these reasons, and then the county court judge would be able to examine those reasons to see if there's an error of law in them, wouldn't he?
Well, that is a point. That is a point I made before the county court, and your lordships may recall that His Honour found that he didn't have to decide whether that concession was properly made.
Yeah.
Respectfully, he was probably wise to do so, and the reason for that is found in Michelak. If I may take your lordships to the decision in Michelak, which the fundamental, the salient parts of which demonstrate why the process of supervisory review is simply not adequate to determine whether or not there's been discrimination. May I take
just
your
before we look at Michelak, can I throw one more hypothetical into the mix and make it clearly a discrimination issue rather than a different policy issue?
Yeah.
I suppose it's apparent on the face of the decision. Imagine, just try and take it away from the facts of Ms Adesotu's case. A Turkish applicant for housing is told on review, there are too many Turks in this borough and we're not going to give you any housing, yours faithfully. Now, what jurisdiction would have to be invoked to challenge that? If the applicant for housing brings a section 204 appeal, would the council be saying, sorry, you've got to bring the claim under part 9 of the Equality Act, claim with assessors and so on.
Yes. And to support that proposition, I return to section 113 and 114. Because that only gives two options: judicial review or a claim. Nobody here is arguing that a 204 appeal is a claim. And we know from Hamlet that it's not a judicial review. So the only way in which, and we've seen from the passages in Hamlet and Summers, the only way in which that allegation alleging discrimination, for example, under Part 3, could be brought properly before the court is in a Part 7 claim invoking the County Court's originating jurisdiction, not its appellate jurisdiction.
So, on my Lord's example, which is direct discrimination on the ground of race, national origins, you say that that is not a ground on which you can challenge a review decision.
No, I don't say that. I say that the point of law simpliciter can be raised in the 204 appeal,
Right.
but the County Court is simply not in a position to determine the alleged unlawful act. Because in order to...
Why not?
Because of
I mean,
section...
in my Lord's example, the review decision says there are too many Turks in this borough, you're a Turk, we're not going to house you. Well, what is there for the County Court to determine except the question, is that legal?
Again, my lord, I fall back on the statutory provisions. If the allegation, and I do base it on the facts of this case, if the allegation is you have breached section 29 because you have discriminated against me because of your disability, that type of challenge can only be brought in accordance with sections 113 and 114, and because of what we've seen in Hamlet and Summers, can only be brought by way of a Part 7 claim in the County Court.
Right.
Does that help?
Part 7 of the Equality Act.
No, I'm so sorry. Part 7 of the Civil Procedure Rules.
Oh, I see. Yeah.
Well, it certainly made your position very clear, Mr. Underwood.
Thank you. I don't go so far as to say that the point of law that arises from the alleged discrimination cannot be raised in a 204 appeal. I accept that. But in order to establish the unlawfulness, one first has to establish the discrimination. And that is what the County Court cannot do in a 204 appeal.
Well, in the example I gave, the council wouldn't have what might be called the bub point, that the judge has got no jurisdiction to determine issues of fact, because there aren't any. But you say before one gets to the bub point, you rely on the terms of section 113 to say that there is simply an exclusion on the grounds of jurisdiction, even when there is no conflict of no dispute of fact.
Yes. Yes. As I say, I think I've made my position clear. The alleged unlawfulness can be raised as a point of law in the appeal, but in order to establish that unlawfulness, because of section 113, 114, and in cases where there is a dispute of fact because of BUB, that determination can only be made in the context of a CPR Part 7 claim.
Right, so you bring your claim under CPR. Does the court who hears that claim have power to quash the decision? Or are you limited to damages?
I think that's what's called a judicial curveball. That raises a whole range of issues.
Well, let's give you an hour to think about it.
I'm grateful.
2 o'clock.